Good afternoon. Our case for argument this afternoon is BD versus Samsung SDI. Mr. Taylor.
Good afternoon. Thank you, and may it please the court, Jonathan Taylor for the plaintiff appellant. I'm going to try, if I may, to reserve 3 minutes for rebuttal to see if I manage to do that. As this court is aware from its prior opinion ordering jurisdictional discovery, this is a products liability case brought by an Indiana resident who was injured by a Samsung 18650 lithium-ion battery in Indiana. And the question is whether the Indiana courts may exercise personal jurisdiction over Samsung consistent with due process. Jurisdictional discovery has shown, and Samsung does not deny, that it sells and distributes hundreds of millions of 18650 batteries worldwide, including many millions to major U.S. companies that then pass along the batteries to consumers in all 50 states, including Indiana, by incorporating them into products like laptops, power drills, and electronic vehicles.
Mr. Taylor, I'm sorry, go ahead.
Sure.
Mr. Taylor, with regard to the evidentiary record from the last time we were here, we have the Juan deposition.
We do.
We've got the written discovery. Was there any other change in the evidentiary record that you either want to bring to our attention or that you think merits a finding for your client?
I think the gap that we had last time, so before, there was already evidence in the record showing that these batteries were available on the shelves in Home Depot in Indiana, and they were incorporated into consumer products like power drills and whatnot. What was missing, though, was how they got there, whether Samsung directly contracted with these companies and shipped these batteries directly to the companies, and who these companies were, and we know that now. We know these companies are very, very large nationwide companies. They're household names. They sell their products throughout the country. Companies like Tesla, Hewlett-Packard, Dell, Black & Decker, you name it. And when Samsung sells its products to these companies, it ships the batteries directly to them in bulk. And so we know that. And so I think the question then, for purposeful availment purposes, is whether those contacts, coupled with an additional piece of evidence that I omitted from my response to you, Judge Brennan, which is one of the questions that this court had in its prior opinion, which is, does Samsung restrict or attempt to restrict the geographic scope of where these batteries go? And we found out that it doesn't do that at all.
That's the third bullet point.
That's the third bullet point. So when we're talking about the scale of these sales, the direct contact with large companies with known nationwide distribution networks, and no attempt to circumscribe the geographic scope, I think it's the only reasonable inference is that Samsung knew or should have known or expected or should have expected that its batteries would make their way in large quantities to Indiana. And that's the only question for purposeful availment purposes.
Mr. Taylor, you say known nationwide sales. Is there anything in the record that would point us to Samsung knowing about the nationwide reach of its customers?
There's nothing in the record. I think it's a fair inference when you contract with a company like Hewlett-Packard or Dell or Black & Decker. And specifically when you're doing so in Samsung, their defense on the merits is we know exactly where these batteries are going. There's a careful vetting process. We want to know how they're going to be used, how they're going to be encased, and I think it's just defies belief that Samsung wouldn't know when it's shipping as many batteries as it is to a company like Black & Decker for incorporation into power drills, and when Samsung dominates the global market, that those batteries aren't going to appear in large quantities in states throughout the country.
But this litigation doesn't have anything to do with that stream of commerce. It has to do with a different stream of commerce for the individual batteries, not the batteries as a component part to another product that's marketed nationwide in vast quantities.
Yeah, and Chief Judge Sykes, I think your question is about relatedness.
It is.
And we've been talking about purposeful availment, and I think that the stream of commerce analogy, if you will, is useful. And in many cases, when you're talking about stream of commerce, you're just talking about an authorized distribution chain. And once you've got purposeful availment, you kind of have relatedness too, because
I don't think the cases stand for that.
I think in general.
Relatedness is a required
distinct-
showing that needs to be
Right,
made
and I
to
think the
establish
showing-
personal jurisdiction.
Right, and I think here there are two inquiries. They're distinct. We briefed both of them because Samsung has made arguments on both prongs. And I think if you are with me that the context that we're relying on
Well, we
are
don't
minimum
even have to make a
contexts.
decision about whether we are or not. If there's no relatedness, if this litigation, which pertains to an individual
Right.
battery that was sold in a different stream of commerce without authorization, and so therefore certainly without any expectation, then there cannot be relatedness. So it doesn't matter whether we apply the knowledge version or the targeting version of the
No,
stream of commerce test for purposeful availment purposes.
I don't think that's quite right. And what I would say is the purposeful availment inquiry is designed to determine whether Samsung is seeking to avail itself of the Indiana market with respect to these 18650 batteries. And what it allows you to do...
Which market?
The market in the state, there's only one market,
The
one
market for
geographic...
finished products, to use the Asahi formula, the market for finished products
Well,
with this component part. If your client had been injured by a Black & Decker power tool whose battery, Samsung SDI battery, had exploded, this would be a much different case.
I agree with you, and then I think we're on board on purposeful availment, and then the question just becomes, are those contacts which would furnish a basis for personal jurisdiction if, in the hypothetical that you just gave, they necessarily would also satisfy purposeful availment here? And then the question becomes a relatedness question. That's the exact question that the Texas Supreme Court answered in Morgan. It's the exact question that the Sixth Circuit answered in Sullivan. It's the exact question that the Mississippi Supreme Court answered in Dilworth.
And there's cases going the other way. There's definitely a split on this, and the Supreme Court will have to weigh in at some
I
point.
get it,
So
I get
that's
it.
where this is going.
And I think, but I just want to be clear about analytically where we are. And I think once you're at the second stage and you're talking about relatedness, then Ford's test kicks in. And what the Supreme Court did in Ford is it announced a test that was designed to cover the vast majority of products liability cases, at least those involving mass products of the sort that we have here. And that test is when a company serves a market for a product in a state, and that product causes injury to the state, in the state to one of its residents, the state's courts may entertain the resulting suit. And that has three requirements that I think are stringent and ensure that there's a tight connection of the sort that is generally required to support specific personal jurisdiction. The first is an identity of product, a unity of product.
But here you don't, I mean, I guess, going I guess my question is, are these the same, is there a unity of products though? Because what Samsung was creating were batteries to be put in these battery packs that go into these consumer products. As I understand it from your expert's report, what gave rise to this lawsuit was two batteries. One was a Samsung battery, the other one was not. And also that battery was rewrapped. So it didn't even have a Samsung name on it. It was H-Ohm.
Right.
And so the question is, in that context, I'm not sure whether such a straightforward purposeful availment test as we see in some of these other cases would necessarily apply. It seems to me that there needs to be a little bit more than the fact that Samsung knew that its battery packs would end up in Indiana.
So I want to be clear about what Samsung sells. It doesn't itself package the cells into batteries. It ships them in bulk.
But it doesn't ship
companies
them in
that
bulk into Indiana or even this country, as I understand it. So I think it comes down to how much knowledge does Samsung have that its products would end up in Indiana, that product being somewhat different from the product that allegedly caused the injury in this case.
Well, let's take a hypothetical. Let's say that I'm an Indiana resident, I go to the Home Depot down the street in Indiana, I pick up a Black & Decker drill, and I disassemble the batteries that are inside. They're Samsung batteries, and maybe I put them in my pocket, try to use them in my e-cigarette device, and they blow up. I think there's indisputably jurisdiction in that case because there's a causal connection. That came in through the authorized chain of distribution, and it would satisfy the requirement of relatedness, even that Ford, the company, proposed in Ford and that the Supreme Court rejected as overly strict. And so then the question becomes, why would the answer be any different here if the question is just one of state power and whether Samsung has submitted itself to the jurisdiction of this state with respect to these exact types of products?
Let me give you an hypo. Let's say there's a car. You bought a car, and the car has, tires on it, obviously, right? And for whatever reason, you took off the tires and sold it to someone else, and they got into an accident. Okay, would that subject the car manufacturer to jurisdiction based upon the sales of the car?
I think
if the tires failed when they were separately sold to someone else as a different product?
I think if the theory, I think I want to be clear about who you're suing. If you're suing, if your theory of liability is based on the product that was manufactured by the car manufacturer, so it's the car, then there's jurisdiction there under Ford. And I think that doesn't mean that the manufacturer is going to be held liable if what actually caused
So your answer to my question is yes, there would be jurisdiction?
There would be jurisdiction. And I think that kind of has to be the answer under Ford, because Ford, recall, involved used cars. And used cars, as we know, might involve aftermarket parts that get put in by different manufacturers and maybe some wiring and all sorts of different modifications that occur. And if there is an accident that takes place with respect to that car later on down the road, we know under Ford that if the allegation is that the product that Ford sold caused an injury, there's jurisdiction. That doesn't mean there's liability. There might be a strong case that what actually caused the injury there was some part that was put in by somebody else somewhere along the line, not Ford, and there's going to be no causal link of the sort that could support a finding of liability. But I want to be clear, the foreseeability inquiry for purposes of substantive products liability law is different from the foreseeability inquiry for purposes of personal jurisdiction. And this is exactly what the Texas Supreme Court, at the urging of the Texas Solicitor General, pointed out in the Morgan case.
Thank you.
Thank you.
Mr. Emsch.
Good afternoon, Your Honors, and may it please the Court, Christopher Amsch of Herbert Smith Freehills, on behalf of the appellee Samsung SDI Co. Limited, which I'll refer to as SDI. We view this appeal as very straightforward because this Court in January 2024 gave the parties clear guidance concerning what it felt was the Seventh Circuit standard for purposeful availment and for application of the stream of commerce theory in products liability matters. And the Court gave the parties 3 questions that it felt would help answer the more fundamental question of whether SDI is subject to specific personal jurisdiction in this matter. And that really is the key question for this appeal, is what is new now that the parties have completed jurisdictional discovery that was not before the district court and was not before this court beforehand. And so it's really 4 things, and that would be appearing at document 135-1 set forth in the declaration of plaintiff's counsel. Exhibit 1 was the transcript for the deposition of SDI's corporate representative. The second was a letter that SDI sent to one of its corporate customers after it had a reason to believe that some of the battery cells that SDI had shipped to that customer had ended up in U.S. vape shops, and explicitly directing that customer, if it had any involvement in those illicit sales, to stop the distribution in that manner. And then the third and the fourth exhibits were compliance agreements, as they were titled, in which SDI even upped the ante and said, not only am I directing you to stop distributing 18650 cells if you are, but to the extent that SDI determines that 18650 cells that it shipped to one of these customers end up in a U.S. vape shop, there will be a penalty of $20,000 per battery cell. So 50 battery cells that end up in a U.S. vape shop, $1 million. Those are the only additional facts that came into the record after jurisdictional discovery was completed and after this court remanded the matter. And so in light of those new facts, I would then direct the court to the three questions that it identified in its January 2024 order. The first being, did Samsung SDI know individual 18650 batteries reached consumers in Indiana? Nothing that I just discussed by way of the additional evidence in the record shows that SDI had any knowledge that Indiana consumers had obtained its 18650 cells, whether by way of a vape shop, whether by way of dismantling a power drill, to use the example that Mr. Taylor used. And in fact, SDI's corporate representative even averred that this was the first case in Indiana in which SDI had been sued as a result of a consumer's use of its 18650 cells. So then I would turn to the second question, which is, did Samsung SDI expect that its 18650 battery cells would reach consumers in Indiana? And the answer to that question, based on the record developed in jurisdictional discovery, also was no. There was no reason for SDI to expect, as a result of its contacts, as a result of any activity that it conducted in the United States or abroad, that consumers would obtain its 18650 cells. In contrast...
Not even embedded in another product, like a power drill or a...
Well, I think, Your Honor, you could view the question two ways. If you view it on the basis of an individual cell, I would say absolutely not, right? And if you start thinking about sales of 18650 cells at vape shops, I think that's an improper consideration because that's the result of the unilateral activity of a third party. If you view it in the light you just put it, which is you have 18650 cells that have been incorporated into an electric car, a snowblower, a power drill, did SDI have reason to expect the cells would reach consumers in that capacity? And I think the answer there is the record would need to contain some evidence concerning what products in particular would have contained those 18650 cells, what the distribution and sales model was for those products. And so, for example, if we're using a Stanley Black & Decker power drill, you would want to see some knowledge on the part of SDI that Stanley Black & Decker has a regional distributor, for example, or has a network of other companies that ship the product into every state in the union, and in particular Indiana, because that is an important point here. You cannot purposely avail yourself of Indiana just by purposely availing yourself of the United States market as a whole. This court's decision in Jennings was very clear about that. The United States Supreme Court, even in Nicastro, was clear about that. It rejected the New Jersey Supreme Court's position that as a result of kind of modern changes in commerce, by shipping a product into the national stream of commerce, you've necessarily purposely availed yourself of every state in the union.
Let's follow up a little bit on the
Sure.
deposition that was given by the corporate representative. The corporate representative changed. On a no 30B6 deposition, witness who's been prepared is going to say, we sell batteries in Indiana, right? But there seem to be a series of admissions which may create a syllogism that some would argue would be purposeful availment. It would be, we know who our customers are, we contract our batteries to our customers, and we didn't limit where our customers sell the products. Is that going to be enough here for purposeful availment?
I would say no, Your Honor.
And why not?
Because the test has never been, I guess, what I would call purposeful disavailment, that you're subject to specific jurisdiction in every state in the union except for the ones that you've specifically directed your customers not to ship the product there.
So is there any state then in the United States where Samsung SDI would be subject to specific personal jurisdiction?
Well, it would depend on the nature of the claim, Your Honor. If you had
Assume it's a claim like this.
an e-cigarette,
Yes.
I would say no. And the reason is because SDI has not conducted any activity, whether abroad or in the United States, that would evidence an intent to purposely avail of any state's market for individual 18650 cells, which is the product at issue in this case. And that was the formulation that this court adopted in its January 2024 order. That was the first question. Did SDI know that individual 18650 cells would reach consumers? And as Chief Judge Sykes just pointed out, that's a very different form of purposeful availment than when you have 18650 cells as the component part of another product.
What about the hypothetical that Mr. Taylor raised, where someone took apart a battery in a Black & Decker power drill to use for their vape, vape pen or whatever they're called?
I think I would not concede, and I wouldn't necessarily agree that you necessarily have arises from specific jurisdiction in that case, because it would tend to sever the causal link in the chain when you have a consumer that's doing something that's totally unreasonable, right? The entire basis for specific jurisdiction is what can reasonably be expected, and what lawsuits should the defendant reasonably anticipate having to defend as a result of its own contacts in the forum. So if, and as an initial matter, you would need to have the evidence, Your Honor, that SDI had purposely availed itself of the forum with respect to the shipments of the power drills containing the 18650 cells. And I'm not saying that you have any of that type of evidence here. But if you had that evidence, you would still have a question about whether you can truly say that injury arises from or relates to any conduct of SDI when none of its conduct would reasonably result in a consumer alleging that type of claim. I know I have 1 minute left, and I just would like to touch briefly on the point of relatedness, as Chief Judge Sykes mentioned earlier. Mr. Taylor has made arguments, at least in his briefing, about Ford and Ford's applicability to this case. As this court acknowledged in its January 2024 order, Ford, this is not a Ford case. Ford involved Ford Motor Company's extensive sale, distribution, marketing of the subject product, the vehicles that caused the injury in that case. And if you put it at a very high level, one might argue Ford was asking essentially for a get-out-of-jail-free card. It had shipped thousands of vehicles into the forum state, and it just so happened that the two vehicles that caused the injuries at issue had been sold and manufactured in another state. But Ford even conceded in that case, if it had been any of those other vehicles, any of the thousands of Crown Victorias and Ford Explorers that it had shipped into Minnesota and Montana, there would unquestionably be specific personal jurisdiction. That is not what SDI is arguing here. What SDI is arguing is we have never shipped 18650 cells into the U.S. stream of commerce, into the international stream of commerce, in any way that would result in a consumer purchasing one of those 18650 cells, whether for use in an e-cigarette or any other application. And for that reason, I would say that Ford is clearly distinguishable. Thank you.
Thank you. Mr. Taylor, I think your time had expired, but I'll give you an extra couple of minutes for rebuttal.
I appreciate the accommodation, and I'll try to be very brief. Thank you, and may it please the court. Just a few very quick points in rebuttal. First, on purposeful availment, I heard my friend effectively take the position that the record in this case is insufficient to establish minimum contacts and is insufficient to allow for the inference that Samsung knew or intended that any of its batteries would make their way into Indiana, even through the authorized distribution channel, and that you'd need more evidence. That's inconsistent with cases like Nelson and Geodis. I mean, the Nelson case, for example, which is still good law in this circuit, involved a Hong Kong manufacturer of flannel shirts sold to another Hong Kong company that in turn sold to Woolworth Company, and Woolworth sold shirts nationwide in all of its stores, and 3 of those shirts ended up in a Woolworth store in Indiana, or rather Wisconsin, and this court said that that's enough under the stream of commerce test, and it was enough because the Hong Kong manufacturer knew that Woolworth sold its products throughout the country. And I think if a few isolated sales is enough there, and there's a basis of knowledge that can be inferred without any forum-specific evidence, I think it would have to be enough here. It's an a fortiori case. Geodis is very much of a piece with that. And it cannot be that by targeting all 50 states, you actually don't target any of the states. And so I don't think this is actually a close question under purposeful availment at all. It is a more difficult question under relatedness. And I think the problem there is that my friend points to no case from this court or the U.S. Supreme Court that stands for the proposition that the personal jurisdiction inquiry travels beyond the state's borders and cares about how a product is used once it's within the state, or how the plaintiff obtained the product. None of that is the subject of personal jurisdiction. It is the subject of products liability. And my friend, in answering the hypothetical that I posed, said that he doesn't think there would be jurisdiction there because it would the unauthorized use would sever the causal link, which I guess is a proximate cause theory of personal jurisdiction. That's way beyond what the Supreme Court rejected in Ford, and it's akin to the kind of argument you make on the merits. It has nothing to do with the jurisdictional inquiry. And finally, I would just point out that the upshot of my friend's position on relatedness is that Samsung takes the position that it cannot be sued anywhere in the United States, and that we've got to go to Korea to sue them on a theory of strict liability that this product is unreasonably dangerous, and I would submit that that's unreasonable. Thank you.
Thank you very much. Our thanks to all counsel. We'll take the case under advisement, and that concludes this afternoon's calendar.